This is November 4th, 2021, letter to the editor, Valley Voice. In the continuing saga of my study of the injustice system, I followed the inquest into the RCMP shooting of Peter DeGroot with great interest. Thank you, Jan McMurray, for your comprehensive summary of the inquest. Of course, my concern is the killing of a citizen by the justice system when they perceived he might be a threat, when he failed to follow their wishes. In my appeal against the conviction of failing to comply with the Income Tax Act and file income tax statements, the Crown cross-appealed in the principle of retributive justice rather than restorative justice and requested an increase in the penalties. I had made it clear at trial in the provincial court that the purpose of my attending court was to report crimes in the justice system, extending throughout, from lawyers not complying with court orders, law societies condoning and covering up criminal activities, judges doing the same, and the Judicial Council and the Minister of Justice all doing exactly the same. One of the elements of my appeal is that a judge failed to act judicially. The job of a judge is to be impartial, to hear the facts as presented to court, apply the law, determine fault, and pass sentence as required, as prescribed by law. Part of my argument at trial was that the sentencing provisions in the Income Tax Act included a possibility of jail, which in similar cases had been determined unconstitutional. Complying with the law, I provided the Attorney General of BC and Canada 2 weeks' notice of my argument. I noted that the Minister of Justice had also failed to comply with the Charter of Rights and respond to my charter complaint to have judicial conduct constitutionally checked by Parliament, as judges are currently asserting that they have a right to reject any and all evidence that any Canadian could provide to court, up to and including their own official record of trial, the transcript. I presented my argument based on the precedents previously established by court decisions, and the Crown prosecution responded that they have no comment at this time. However, the judge ruled against me, clearly partial to his employer, the government, not to the people. Part of the difficulty moving forward within the judicial system will be dealing with the duty of a judge to not hear cases where he might have a conflict of interest, known in law as recusal. A judge is disqualified if a fair-minded observer might reasonably apprehend that the judge might not bring an impartial mind to the resolution of the question that the judge is required to decide. The principle gives effect to the requirement which reflects the fundamental importance of the principle that the tribunal be independent and impartial, lest the integrity of the judicial system be undermined. The question is one of possibility, not probability. Thanks once again for bearing witness. fundamentaljustice.com